Good morning. Whether you're oddly fascinated by our topic or simply trying to satisfy belatedly your CLE requirements, welcome. Over the next hour, Edward and I will talk with you about the current regulatory environment on wage protection, the importance of accurately classifying a worker as either an employee or an independent contractor, the severe consequences of both misclassification and failing to pay wages as promised, and the hazards of joint employment, that is, the sharing of the compensation burden with your business partner. You're bound to have some questions, excuse me, and as Amish explained, there is a Q&A feature. We'll generally park your questions received and address them at the close of our presentation. Off we go to the next slide, please. Let's first talk about the present landscape for wage regulation. Next slide, please. As night follows day, a change in presidential administration brings a policy direction change also. We're now through the midterms, and the impact of the progressive agenda implemented by President Biden is being felt. The emphasis has shifted decidedly toward increasing worker protections and rights, without the corresponding increase in worker responsibilities. As we heard last night, the aim of the Biden administration is to restore the dignity of work. And you've seen it in many forms. The increase in wage rates on federal contract projects, the EEOC's inclusion of low-wage workers as a vulnerable population in the agency's strategic enforcement plan for this year, legislative attempts to assist recruiting efforts by labor unions, the enactment of the Pregnant Workers Fairness Act of 2022, which requires employers to make reasonable accommodations for pregnancy-related medical conditions. And most dramatically, the recent proposal by the Federal Trade Commission to outlaw most non-compete agreements. The shift, however, isn't isolated to the federal level. Many states have increased their statutory minimum wages. They have increased other wage rates, the so-called living wages. And they're also enacted pay transparency laws to further pay equity. Especially relevant for our discussion this morning, many states, including red and purple states like North Carolina, are cracking down on the misclassification of employees as independent contractors, and also cracking down on the withholding of wages as promised. While a number of factors account for this increased government activity, two factors seem to predominate. First, it's just sound public policy that workers get full measure of their labor. Second, no elected representative will refuse to siphon off from a tax revenue stream. The more W-2 wages paid, the higher the tax proceeds that are realized. Enforcement by both private and public actors has recently been focused on the construction industry, which historically among lower tier subs has across the board identified and classified workers as 1099 workers. One possible explanation for this dynamic is that it's easier to get a TIN, a tax ID number, than a social security number for W-2 purposes. This current emphasis on worker protection resonates especially well with the Gen X, the millennials, and Gen Z workers. They consider labor unions much more favorably than us boomers. Please advance the slide. Let's get down to basics so we're all singing from the same hymnal. Next slide, please. There are two forms of misclassification for compensation purposes. First, an employer makes a mistake in classifying an employee as exempt rather than non-exempt. The key difference between these two classifications is that only non-exempt employees are eligible for overtime pay. exempt status is determined by the Federal Fair Labor Standards Act. To qualify for the exemption, employees generally must meet certain white-collar tests regarding their job duties and be paid on a salary basis at no less than $684 per week. What does not determine exempt status are job titles or job descriptions. As noted in the slide, the DOL will propose changes to the overtime rule by raising the salary threshold. This all may sound familiar because it is. The Obama administration proposed a rate of $913 a week. That was ultimately blocked by a court ruling which said that the rate was too high and the DOL had exceeded its authority. Thereafter, the Trump administration raised the rate less substantially from $455 to the current $684 a week. The net effect of raising the threshold is that more overtime will be paid and that some workers will receive a government-mandated pay raise. The second form of misclassification is to treat employees as 1099 contractors. That, I believe, brings us to our first polling question. True or false? A company can avoid misclassification liability with a well-written consulting agreement containing a provision clearly defining the consultant as an independent contractor as opposed to an employee. Remember, for those of you seeking CLE credit, don't leave it on the table. You need to respond. And don't worry, Edward isn't going to track you down and shame you in your office if you have the wrong answer.
Thank you, Mike. And while our attendees are responding, I see we've got a number of responses in. You know, you mentioned that the Department of Labor, in its proposed rule, is likely to increase that threshold from currently $684 a week or $35,000 annually. And while I'm not as close to the sun on this issue as many commentators, there's discussion amongst those who are close to the Department of Labor suggesting that that increase could be as much as $900 or $1,000 a week, annualized at $47,000 or $52,000 annually. So that's quite an increase.
Quite an increase, and as you can predict with certainty, that whatever the rule is going to be, it's going to meet with a judicial challenge.
Of course.
In the meantime, I see that we're going to close our poll, and that 84% have registered false, that you can't paper your way through liability. What say you, Edward?
I've got to go with false, Mike.
All right, you are correct, and I'll just let you take it from here.
Thank you. If we could go on to the next slide then, please. So now, Mike mentioned we're talking about in two concepts of misclassification. Here, we're going to talk about independent contractor misclassification basics. So for those of you who aren't familiar with those basics, we need to talk about what is the test for whether an individual is an employee or an independent contractor. Well, the lawyer's typical answer is it depends and it varies state by state. Now, there are some federal regulations that define the elements of an independent contractor. The Internal Revenue Service, the Internal Revenue Code has its own test. The United States Department of Labor has certainly its tests, but each state laws have a myriad of different tests, myriad of multi-factor elements and analysis. But you always are safe with starting by the presumption that the vast majority of workers are employees. We'll go into detail on some of the elements of particular tests amongst the states, but by and large, no matter the test, no matter the state, one factor predominates the analysis, and that is the degree of control that the principal, the employer, imposes over the manner and the means of the work that is being performed. And that's the most important factor. And when I say control over manner and means, what I'm talking about is the employer or the principal telling the worker where to go, when to go there, how to do the work, following established procedures and protocols, being subject to the employer's human resource policies and otherwise. Or on the other hand, is the employer or the principal simply concerned with the end product or the end result? Now, we'll talk about federal, state laws in Virginia, Maryland, the District of Columbia, and North Carolina. So the bottom line is we need to pay attention to the state laws where employers, individuals are located. And as we see here, having an independent contractor agreement is not dispositive of the issue. If it walks like an independent contractor, talks like an independent contractor, it's probably an independent contractor. Although we will talk about having independent contractor agreements is quite valuable. Next slide, please. So we'll talk about the California ABC test. In California in 2019, their General Assembly codified this ABC test, which, not surprisingly for those familiar with California employment laws, is the most stringent test in the country. You can only be an independent contractor under the ABC test if 3 criteria are specifically met. Number 1, the worker is free from the control and direction of the hiring entity in connection with the performance of the work. That's what we talked about on the previous slide, this control over manner and means and methods of doing work. Number 2, the worker performs work that is outside the usual course of the hiring entity's business. Well, what does that mean? The easiest example that I like to provide employers is one within the construction industry. If you're an employer who is engaged in a trade such as roofing or commercial electrical contracting, in other words, your principal job as an employer is providing roofing services, and you employ roofing technicians. But then you have a separate group of individuals who are independent contractors who are also roofing technicians. Well, that work, being a roofer, is within the usual course of the hiring entity's business. On the other hand, if I, as an individual, I own a small business, I hire a painter. I'm not in the business of painting. That painter is outside the usual course of my business. So that gives a little color and explanation to what we're talking about there. Third, the worker has to be customarily engaged in an independently established trade, occupation, or business in the same nature of the work that is performed. So this worker has his or her its own independent business, and that's what they do regularly for other hiring entities. Now, 33 states have adopted tests that are very similar to this ABC test. The ABC test was supported by the Biden administration as a national standard. Next slide, please. So what are the reported impacts of independent contractor misclassification? I think Mike touched on this a little bit in his introduction, but it's the protection of the workers or the harm to workers that we see with misclassification. Number 1, the workers are robbed of wage and hour and overtime protections. They have no overtime rights. So for hours worked in excess of 40, they don't get paid at time and a half or paid at whatever the rate of a particular state that is ascribed for overtime. They have no protection under traditional state or federal discrimination or harassment laws. So for example, they're not protected against discrimination based on race, gender, national origin, sexual orientation, disability, etc. They don't qualify for parental or sick leave rights that may apply to employees in specific states. They're not entitled to benefits such as health insurance, participation in retirement plans and other voluntary benefit programs that employers provide their regular employees. They're not protected by workers' compensation laws. So if an individual who is misclassified as an independent contractor gets hurt on the job, they're left with essentially no recourse under state workers' compensation laws that provides wage loss replacement, medical benefits, and others. And they don't get the benefit of having unemployment rights.
Well,
There's all.
Edward, let me interrupt. Let me go back to your top point. No wage and hour protections. Does that mean that an independent contractor doesn't have a minimum wage, or that there are no protections against child labor if you're an independent contractor?
Great point, Mike. Great question. Absolutely. They are without those protections. State and federal wage law not only provides for overtime compensation, but of course has mandatory minimum wage requirements. And to your point, they're not protected by child labor laws that govern the nature of work that can be performed, the hours of work that can be performed, the number of hours that can be performed, work can be performed. So good question. And of course, there's harm to the government. The government loses out on its share of tax withholding obligations, employment taxes that are paid in the ordinary course for regular employees. Similarly, the government loses out on the mandatory contributions to the Medicare system. On to the industry. Non-compliant companies can underbid those who properly classify their workers, and it provides a competitive disadvantage. And frankly, I hear this frequently from many of my clients, and in such a frustrated manner, where they are doing things the right way, classifying employees correctly, and the employer down the street is doing it the wrong way, and they're able, because of their savings for having independent contractors, to get jobs that often clients that are doing it the right way don't, because of cost. Next slide, please.
And as we go there, Edward, it's just not sour grapes. There's been RICO actions against hog processing companies because they've used illegal labor and cheaper labor.
Well, it's correct. And, you get into a whole separate basket of issues on, how certain industries and employers have preyed on those vulnerable populations, resulting in the commission of essentially of crimes. So it's much more on employers' radar these days, and with the significant government crackdown and emphasis on these issues, employers that are doing it the wrong way are getting caught, and the penalties and punishments are appropriately meaningful. So if we're now on slide 11, Virginia worker misclassification. So here we're going to see a trend amongst some of our states that there is a presumption that individuals are employees under Virginia law, unless specific criteria for independent contractor relationships under federal IRS guidelines are met. And to summarize what some of those guidelines and requirements look like, the common theme of behavioral control comes back. Does the business direct and control what work is accomplished and how it is done? Do they provide training, instructions? Are the workers subject to reviews and performance reviews and held to performance standards or production standards and things of that nature? Financial control. Does the worker benefit from his or her own business? Cover their own business expenses? Provide their own tools? Enjoy profits and suffer losses? Those are elements of an independent contractor. We talk about independent contractors needing to provide their own tools of the trade. In the good old days, that was, people think about the tool belt, the hammer, the pliers, the nail gun. Tools of the trade now, mean things like technology, computer hardware and software that may be owned or licensed. And does the independent contractor, one typically has the ability, because of the way they operate their independent business, to enjoy or have some control over the recognition of profits or losses, depending on the way that they run their business. Let's look at then the relationship of the parties. Are there contracts between the parties that clearly establish an independent contractor relationship? Even though we know contracts alone are certainly not dispositive. If you have a good, strong contract and that contract is followed, that can be one compelling element of an independent contractor. But does the so-called independent contractor, are they provided benefits? If they are, that would be a hallmark of a classic employee. What about the duration of the engagement? Clients often come to us and say, we'd like to engage this person as an independent contractor. We want to put them on a year contract that auto renews. Well, the more that the independent contractor is tied to that single employing entity, working only for that entity for long durations of time, they start to look like an independent contractor as opposed to an employee. Under Virginia law, the VA Department of Taxation is charged with investigating misclassification and can impose civil money penalties. The law also provides for a private right of action, meaning that the individual can bring a civil lawsuit against the hiring entity. And there are strict provisions regarding anti-discrimination and retaliation for complaints about misclassification or for participating in investigations. So therefore, a worker who complains that he or she may have been misclassified or that another individual was misclassified, they are then cloaked in the protection of an anti-retaliation provision that means their employment status can't be adversely impacted because they lawfully came forward and made a report. That's very similar to other anti-retaliation and anti-harassment provisions in many state and federal laws. Next slide, please.
Well, Edward, as we're transitioning, say I represent a North Carolina-based company with no facilities in sister states. Why should I care about what's happening in California or Virginia?
Great question. And, might be a question for the audience. Why are we talking about California? Why are we talking about several of these other states? Well, I think the easiest answer is, while remote work pre-COVID was a thing, we now know that it is often the norm. And remote workers, if you're in North Carolina, if you're a Virginia hiring entity, you may have, and you likely do have, employees who are scattered all throughout the United States. And what employers often don't think about is that the workers in those states are likely subject to those foreign estates' wage and hour laws. They also are likely subject to unique state or even municipal laws governing things like paid leave, paid parental leave, and things of that nature. And COVID has taught us many things, and it's also taught us that our remote workers often move from state to state, sometimes without even our knowledge. So understanding and knowing where your employers are working is really helpful to complying with those state laws and not stepping in a gigantic mousetrap of California state law, for example. Great question. So the District of Columbia, in DC, they passed the Workplace Fraud Act, and it makes it criminal and illegal to misclassify workers. Workers, again, are presumed to be employees unless the employer can prove otherwise. So starting with a presumption of W-2 employment, and then the burden being on the hiring entity to show through its proof and through its the elements of the test that the worker is properly classified as an employee. Now, they adopted basically the California ABC test that we talked about earlier. Some of the penalties can include fines paid to District of Columbia government. They also, if improperly classified, the hiring entity must pay the misclassified worker what they would have been paid if they had been properly classified. And that can be, not an insignificant number, especially if you have multiple independent contractors who are improperly classified. That would include things like overtime, the value of lost health and welfare benefits, leave benefits, and taxes. Those numbers can add up quickly. So the DC Department of Employment Services and the Attorney General's office has been really cracking down on this issue, and particularly in the construction industry, where historically misclassification was either intentionally or unintentionally a problem. These individuals who are misclassified in DC are bringing cases for denial of paid sick leave, which is also a requirement for District of Columbia employers. Next slide, please. Moving on to 13, the Maryland worker misclassification laws. They also have a Workplace Fraud Act, and that focuses on misclassification and wage theft. As with Virginia and DC, there is this presumption of employment. They also apply the ABC test to evaluate whether the worker is properly classified. If there's a valid violation to be found, the employer has to pay restitution to the affected employees. Again, we see a private right of action, meaning the ability to bring a private lawsuit for misclassification. And again, anti-retaliation provisions and protections for those who either are misclassified, report misclassified, or participate in investigations into worker misclassification. Now, moving on to the next slide at 14, I think continuing with Maryland, they really have maybe one of the stricter burden shifting analysis and requirements that the employer has to meet to overcome a misclassification argument. Here's what they require in order to overcome that presumption. Number one, a written contract between the employer and a business entity that describes the work to be performed by the business entity, describes the pay for the work performed, acknowledges that the entity, not the employer, will uphold obligations to pay payroll taxes, unemployment insurance, and maintain workers' comp for all of the entity's employers. And I think this covers around maybe temporary staffing, agency relationships, and others where employees are loaned or shared from a hiring entity to a client who then engages those independent contractors. The entity has to sign an affidavit affirming its independent contractor status and certifying its ability to work for other entities. And that is a classic and a hallmark example of an independent contractor. By definition, an independent contractor is one who serves multiple principals. So the independent contractor is not tied exclusively to one entity. They have the ability to provide that independent trade to more than one other entity or agent. They have to provide a certificate of good standing from the state taxing authority, and prove that the entity holds any necessary occupational licenses. And with that, I believe we'll pass the ball back over to Mike.
Thanks, Edward. As you know, North Carolina has joined the bandwagon of states cracking down on worker misclassification. In 2017, the state enacted the, let me get this right, Employee Fair Classification Act. It begins at North Carolina General Statute, Section 143-785. The Employee Classification section was created within the Industrial Commission to investigate reports of misclassification. So those reports can come from the folks who are on the other end of this this independent contractor contract, or it can come from business competitors. The reports can come anonymously. So the reports will come in about misclassification, and this section's duty is to investigate those. And the section also has a remit to coordinate its enforcement efforts with the Department of Revenue and also the Division of Employment Security. So you have a coordinated government response to misclassification. The statute, however, doesn't define who is an independent contractor. Neither does the State Wage and Hour Act. In the absence of an applicable statutory definition, our courts have relied on common law principles to determine whether there is an employment relationship. The factors that are listed in the slide are hallmark criteria for an actual independent contractor. These factors aren't particularly new. You've heard Edward talk about those, and you've seen them. Other states have picked up on it. But if you're looking for the basis for where these factors are gleaned from North Carolina appellate decisions, you should start with the seminal case of Hayes versus Elon College, which is 224 NC 11, 29 Southeastern 2nd, 137, decided in 1944. And for our Court of Appeals, the case to look at would be Horak versus Southern Real Estate Company, 150 NC App 305, 563 Southeastern 2nd, 47. It's a 2002 decision. Next slide, please.
And interestingly, Mike, that Hayes decision from the 40s has been the seminal gold standard, remains unchanged and untouched. So North Carolina's position has been pretty well established for a long time.
But as we bemoan, it's a fact-based, specific to what's in front of you. So we have a test and we can throw darts, but only a judge's decision is going to let us know who's right on that. Well, in addition to the patchwork of state definitions, there's a federal standard for worker classification. Near the end of the Trump administration, the DOL issued a new independent contractor test. Prior to adopting the rule, the DOL and most courts considered 6 or 7 factors when analyzing a work relationship under the economic realities test. The Trump rule distilled these factors into 2 core factors based on its exhaustive analysis of decades of enforcement cases under the test. Those 2 core factors are: 1, the nature and degree of control over the work, and number 2, the worker's opportunity for a profit or loss. The Biden DOL attempted to delay and then withdraw the new rule. However, the United States District Court for the Eastern District of Texas found that the action was unlawful and held that the Trump rule became effective. Next slide. Not dissuaded, the Biden DOL has sought to change the Trump rule through formal rulemaking. The Biden rule reverts to the old economic reality factors as listed here in the slide. Next slide, please. The Biden rule also has some bells and whistles that's set out in the slide. But one takeaway is that the actual parameters of the final rule are unknown, and whatever they will be, of course, as we discussed earlier, they will face a challenge in court. For now, you'll need to understand and apply the Trump rule. Another takeaway is not to be myopic in tracking independent contractor developments by only following what the DOL does. All parts of the Biden administration are simultaneously attempting to advance the common goal of increasing worker protection. For example, the Federal Trade Commission, in addition to its non-compete rule, has announced in fall of last year that it's adopted enforcement priorities to fight on behalf of gig workers against deception about their pay and their hours, about unfair contract terms, and anti-competitive wage fixing between gig economy companies. Not to be left out, the National Labor Relations Board has signaled that it's open to revisiting the difference between an employee and an independent contractor under the National Labor Relations Act in a case called the Atlanta Opera. That case arose when hair and makeup workers at the opera were looking to join a union. But the opera argued that the workers are independent contractors and not employees, and thus not eligible to be represented. Stay tuned for a decision by the board. I believe that takes us to our next poll question. True or false? Wage theft means when an employer improperly deducts money from an independent contractor's pay. While the folks are grabbing their CLE credit, tell me, Edward, what's your betting line on the Super Bowl?
Well, I'm going to say my betting line is anybody but Philadelphia.
Well, that makes it easy. If you were going to give me a spread, it was going to lead into my joke that talk about wage theft, but
very good. I failed. Well, then I'm probably going to go Philly plus 12.5.
well, we'll need to talk later on that. I'll bring cash. So I see we have full participation. The poll is closed. There's no more votes to be counted. No hanging chads. We have 59% of our folks saying that's false. What do you say, Edward?
This was a tricky one, right? Because I think
Yes.
there was a key word in there. I'm going to have to go with false on this one, Mike. Am I right?
You are. You've stumbled into the truth. Take it from me.
And I think what the key term there was wage theft with respect to an independent contractor as opposed to an employee. But let's talk about increased scrutiny on wage theft. Next slide, please. So wage theft in general, this is fairly common sense. Wage theft is when an employer does not pay an employee what the employer owes the employee. It's very broad. It can come in the form of independent contractor misclassification. It can come in the form of failure to pay overtime, failure to pay minimum wage, failure to pay it all. In many states, it can come in the form of unlawful deductions from pay. One classic example that Mike, I think we run into this one all the time. Employee is let go from the company. Employee may have some company property. It may be uniforms, it may be tools, it may be electronic devices or technology. And Mike, what does the employer say about that final paycheck?
I'm holding it hostage.
They can come get that paycheck when they bring the property back. Well, in North Carolina and in many other states, that's illegal. And it can result in strict penalties. It can result in double the amount of pay that was issued, that was at issue. And to incentivize lawyers to take these smaller value cases with one paycheck, what does it also give them? Attorney's fees. So you can't hold the paycheck hostage with company property, and that's another example of wage theft. But in any event, this always means that wages, salaries, but also other things like overtime, bonuses, commissions, this is what wage theft encompasses generally. Wages are often broadly defined by state law. It's detrimental to the public good because it decreases tax revenue and this suppresses the spending power of its victims. Next slide, please. So new amendments to the Virginia Wage Payment Act add even more enforcement abilities to wage theft laws. Once again, we see another private right of action, meaning another way to bring a civil lawsuit to sue for unpaid wages or other violations of the VWPA, including the timing of payment and, as I mentioned, deductions from pay. There's a 3-year statute of limitations on these claims, meaning that an employee has 3 years to bring that private lawsuit. It allows for collective or essentially class actions where if an employer has a policy or a practice of deducting from pay, for example, that employees can form a class and bring that class action, and anyone who's had any experience with being involved in class litigation knows how significantly impactful it can be from a financial standpoint. Dealt with one a couple of years back on an employer who had a policy of auto deductions for meal breaks, where employees often weren't taking meal breaks and working through meal breaks. Auto pay deductions can be a real mousetrap there. Of course, you can still enforce this law through criminal charges and civil penalties. It not only opens the courthouse doors, but the damages that are at issue for violations of the VWPA include the back wages, triple the amount of damages, meaning triple the amount of unpaid wages. That's called treble damages, 8% prejudgment interest, and once again, of course, the lawyers get paid their fees, which can often be inflated and significant, especially in class litigation. Next slide, please. The DC wage theft, they have the wage payment and collection law. It's one of the most progressive in the country. Wages covers all monetary compensation, once again, including bonuses, commissions, incentive comp, fringe benefits, OT premiums, and basically any other form of financial remuneration that was promised or owed. Courts have found in DC under this law that employers have violated the law by not paying hourly wages, moving and relocation expenses, bonuses, but there's an open question on discretionary bonuses, failing to pay promised severance and commissions. Again, you see class and collective action lawsuits, and those exponentially increase damage awards. Next slide, please. Again, in Maryland, familiar theme, once again, government issued penalties and private right to go to the courthouse and file your lawsuit. If an employer unknowingly misclassifies an employee, but then comes into compliance within 45 days after being issued a citation, the law doesn't give the right to impose civil money penalties. It's sort of a safe harbor, if you will, for at least avoiding the government's civil penalties. If they don't come into compliance in a timely manner, then there can be civil penalties of $1,000 per employee that was improperly classified. Now, on the other hand, if the employer knowingly misclassifies employees, civil penalties go up to $5,000 per misclassified employee. And I will say, under most standards, ignorance of the law is no defense, meaning I wasn't aware of this law that doesn't necessarily get you into an unknowing misclassification. In these actions brought by employees, once again, you see significant damages, very consistent with Virginia and federal law. Thank you. Next slide. Actually, excuse me, I believe we have a polling question.
True or false? A company can avoid misclassification and unpaid wage liability by engaging independent contractors through a staffing company and requiring the staffing company to indemnify it against any and all employment claims.
Yeah, Mike, I'm gonna put the spotlight back on you and let you handicap this one. What do you say, true or false, as to this one?
Well, it looks like we still have some Hamlets out there who haven't made a decision one way or the other. So
Well,
I'll tip my hand and say that it's false.
well, you might have snatched victory from the jaws of defeat there, Mike.
Well, that's what happens when I work next to you. I get some wisdom by osmosis here. The walls are thin, so you give good advice. I just got to keep my recorder going. I think we'll close the polls at this point, and 78% of the folks out there agree with me.
Well, it looks like you got that one right.
Good.
All right. Well, in North Carolina, again, wage theft we see for improper deductions, failure to pay promised wages, very similar in the types of available damages. In North Carolina, we don't have a triple or treble damage standard. We have a double damage standard, so double the amount of unpaid wages that should have been paid. Once again, reimbursement for reasonable attorney's fees. I would also say that there's you're subject to liability for unpaid taxes, unemployment insurance, and then 10% penalties to the NC Secretary of Revenue. Also, there are violations and penalties for North Carolina under the Wage and Hour Act for record keeping violations. So if you get audited and your wage and hour records are audited in a random or a directed investigation by the Department of Labor, you can be fined $250 per worker for a maximum of $2,000. Again, there are actually very strict workers' compensation penalties if an independent contractor is misclassified. Those penalties can be very draconian, and the North Carolina Industrial Commission's fraud division a couple of years ago went on a very aggressive mission to identify misclassification and to provide penalties under workers' compensation laws for failure to properly classify. And then there are also I-9 and E-Verify penalties. But with that, Mike, I think we'll go to the next slide and I'll turn it back over to you.
Thanks. So let's go ahead and advance to the next one, joint employment. Let's be real. Joint employment is a fiction. It's a legal construct under which one employer, the so-called secondary employer, is deemed a joint employer of another company's employees, and thus becomes subject to the same legal obligations as the primary employer. So, for example, under this doctrine, a general contractor is responsible for paying the wages earned by employees of a second-tier subcontractor. It's an interesting type of concept. And understand that this doctrine isn't limited just to the construction industry. Joint employer liability arises with every contingent worker. Consider a pharmaceutical company that's ready to launch a new product. Rather than add regular headcount, the pharma company decides for a myriad of reasons to instead contract a temporary sales force to supplement its internal sales force. This arrangement is fraught with joint employer risks. As you can infer, this doctrine is an equitable means to ensure that employees are fully compensated for their labor by deepening the compensation pool. Next slide, please. As you've heard us say, the Captain Obvious types of points is that the definitions of employee and employer differ among the various federal and state employment laws. Courts interpreting those definitions often apply different standards. To the frustration of the regulated community, there is no one definitive test. Most tests center around the degree of control. There's that word again, control. This is the control exercised by the secondary employer over the terms and conditions of the workforce of the primary employer. And those factors are listed in the slide. Next slide, please. In this slide, we explain the test adopted by the Fourth Circuit in a case called Salinas versus Commercial Interiors, found at 848 Fed 3rd 125. It's a 2017 decision interpreting the Fair Labor Standards Act. This case involved drywall installers who sued both their employer and the general contractor for unpaid wages. The court ultimately found that the general contractor was jointly and severably liable for those unpaid wages. In doing so, the Fourth Circuit created and applied a novel test, which underscores the frustrating point that there's no single test used by the 13 appellate courts for a single employment statute. Next slide, please. This slide sets out the common factors for joint employment liability under the federal anti-discrimination statutes like Title VII of the Civil Rights Act of 1964. Like the FLSA, there is no single prevailing test among the appellate courts. And the EEOC has published its own guidance on joint employer liability. With this type of uncertainty, there is no wonder that joint employment issues will be the grist for litigation mills for years to come. Edward, let me take a peek. I did not see any open questions. In the few minutes that we have available, I think it's of great value to have awareness over the issues that we've raised. So there may be some blind spots by folks who didn't realize that this was there, or this type of liability exists, or the extent of it. Let's go beyond that. So say, for example, there's a question of whether we're properly classifying a worker as exempt or non-exempt. If you just give us like the overview of what a privilege audit would do and what the goal of a privilege audit would be for uncovering this type of liability.
Well, right. So oftentimes we're asked to, under the protection of an attorney-client privilege, go in and evaluate relationships that employers have with their workers. And we look at if an employer has a number of individuals that are classified as a 1099 independent contractor, we'll take a hard look at it, applying the applicable tests, and provide privileged guidance on our views of whether those classifications are proper and defensible, recognizing there's always going to be some gray area, and if there are corrections that need to be made, we can help navigate the best way and maybe the least likely way to draw attention or to draw litigation, invite litigation over misclassification if we need to make an adjustment. And one of the most common areas that I know I get asked to get involved in is the classification between exempt and non-exempt workers. So we'll do an audit over non-exempt or exempt workers, and those are individuals who are on a salary. The employer has them on a salary, and they're not paying them overtime for hours worked in excess of 40. A close to home example, I completed about a 6 or 8 month long audit for about 26 different positions affecting maybe 60 or so workers. And unfortunately, greater than 80% of those we ultimately concluded had been improperly classified. And, changing that classification and switching them to hourly can be a very delicate and problematic process, just because workers often would ask, well, why haven't I been getting overtime then for the past 3 years? So navigating those processes and those reclassifications and conducting those audits are often of significant value, because we all know that an ounce of prevention is worth 10 tons of legal expense in litigation, right?
And to that point, some quick fixes are employee handbook provisions that build in basically a good faith defense to let employees know, hey, we've tried our best to classify you. If you have an issue about it, let us know. That if you aren't getting paid, let us know. If
Yep.
there's been deductions from your salary that you didn't agree to, let us know.
Yep.
So there are lots of things, creative ways to address the liability. And certainly the takeaway from our presentation is not to have any contingent workers or temporary folks or hire independent contractors. It's just to do so with your eyes wide open.